I don't need to hear argument, but I will inform the court, the parties of how the court intends to proceed, but we'll begin with appearances on the record.
Your Honor, Glenn Carter on behalf of Lewis County.
Your Honor, Joseph Thomas on behalf of Brian Cortland.
Thank you. I have received briefing regarding proposed forms of orders, which the court appreciates, and as you may have heard me say earlier this morning, I, in these types of circumstances, will consider the briefing and come up with a form order that is consistent with the court's ruling. What I do want to say at the outset, because this may also enlighten the parties as to the discovery issues, is that the court considers its prior ruling to be finding Lewis County liable for a violation of the Public Records Act. The next stage is going to be the penalty phase, which I understand is going to be wrapped in with determinations of discovery regarding which documents should have been turned over earlier but were not turned over earlier because of the defense that nothing was allowed to be turned over because it was part of the judiciary. I know there has been some discovery to date, and some documents have been turned over to the plaintiff. I did not see any indication in the record of continuing discussions regarding discovery or continued production of documents. What I did see for today was a renote of the prior motion to compel from the plaintiff, which predated the court's ruling, and that the court had denied without prejudice. I will consider the arguments of counsel as presented in their papers regarding the form of the order, and will issue an order in short order. In the meantime, I would expect or anticipate that there will be discussion and possibly discovery between the parties regarding obtaining the documents that should have been provided earlier. And at that juncture, if there are continued disputes and then another CR 26I conference about what action needs to be turned over, then I would anticipate a newly drafted motion to compel or a motion for protective order to be presented to the court within the confines of the current posture of this case. I understand that may be difficult until you have the actual order in hand to see what the court has articulated, and I will, as a result, strive to get that order to the parties as soon as possible so there isn't additional delay. I will, in addition to providing my ruling in the written order that I will sign and draft if necessary, or I can just sign one of the parties if theirs are appropriate, I will set a date for and a briefing schedule for the penalty phase in this case. Let me rewind a moment. I understand that there are additional concerns that have been raised by Lewis County in the briefing regarding the form of the order for the court's ruling, and in terms of continuing to identify the line between documents that reside with Lewis County judiciary and that being part of the judiciary. As the court said at the beginning of the oral argument 2 weeks ago and repeated at the end in making its ruling, the court does not consider documents that should have been with the Law Library Board but were placed with the Superior Court to be prevented from being subject to the Public Records Act. I understand that what exactly that means, it might need further elucidation, and in the court's estimation, that might be an appropriate subject for a motion to compel or for a protective order in discovery to parse that line more finely. Again, this is a unique case that we are dealing with. We've looked 2 weeks ago at the existing case law and authority on what is part of the judiciary. It's not entirely fleshed out. We may need to have additional motion practice, or maybe the parties will agree regarding exactly the line of which documents should have been turned over, but were not in response to your client's public records request. And so I don't need to hear argument from parties today, but I wanted to lay that out to let the parties know that I did find a violation of the PRA against Lewis County. What I anticipate happening now is identifying which documents were constituting a violation of the PRA that needed to be turned over, because that is essential to the court's consideration of what the proper penalty is in this case. So, without arguing, do the parties have any questions at this juncture regarding what the court is going to be doing next? Mr. Carter?
Yeah, Your Honor, I understand that you're going to then prepare an order for purposes of the April 21st ruling, and that will say that Lewis County is liable for the PRA violation, and that I assume at that point that you will try at that time to delineate the distinction between the judiciary and the county for purposes of that order. And I would assume that that for purposes of the penalty phase, that it is still going to be a matter of briefing at the penalty phase, that the judiciary may have been the one that terminated the law library board, and that the judiciary may have been the one that administered the law library, and that that's part of the calculation. As you see the case right now, I know subject to further motion practice, but that's going to be part of the analysis of the factors under your safety.
It could be, depending on how the briefing is presented. I have not considered that other than reading your briefing on the form of the order, and I have not closely parsed that question because that wasn't the subject of adversarial back and forth briefing yet in the court's opinion and subject to the court's additional research and argument, hearing oral argument from the parties. But I don't know at this point. It's possible. It may not be. I haven't closely parsed that legal question yet. Any additional questions, Mr. Thomas?
No, it's just my understanding that if I'm going to bring a motion to compel, that I should rewrite it and have a 26I conference, a new 26I conference before me.
Yes. And
Your Honor, just a second.
no,
Just, look, I think that what we talked about in the alternative order to try to resolve this is that you're going to hold that the law library board was the Superior Court, and I'm not saying put in those words, conceptually, that during the time the Superior Court administered the law library, that it was the law library board. So the issue is, what records did the Superior Court have during that time that would be responsive to Mr. Cortland's request during that time? So I think what you're asking us to do, if it is possible with the judiciary's cooperation, is to assemble a body of documents that would have been the records that were managed by the Superior Court and developed by the Superior Court during that time, and that those are the records that I should be deciding to plaintiff for purposes of proceeding with the case. You've made your ruling, I disagree with it, fine, but you're here to make rulings. And so now I'm trying to facilitate this by saying if I can, with the judiciary's cooperation, get that body of records, then we can proceed, could we not?
precisely. And that's what the next step in this litigation, in the court's opinion, is the provision of documents or the provision of a detailed privilege log, let's say, or exemption log, or something that will allow us to see which documents are there, which are going to be turned over. I don't anticipate necessarily there being records that wouldn't be turned over, but I'm not the one turning them over, and if we need to have further discovery, motion practice,
I'm
we
just
can do
trying
that.
to move this along.
Exactly.
Your Honor, I undertake there's not a need for a 26I conference. I undertake here that we will work with the judiciary, if they wish to work with us, with respect to assembling those records that were assembled during that time or compiled by the judiciary in administering the law library board, and provide them to Mr. Cortland's attorney as quickly as I can do that. I don't know how long that will take.
And that is what the court expects to occur next.
Okay. Thank you, Your Honor.
Thank
I
you.
appreciate your comments.
Absolutely. And Mr. Thomas?
We have a proposed order that we'd like to, it's a modified one of the one that we submitted, and it's slightly amended that I think captures this court's ruling.
By we, you mean you and your client, or you and Mr. Carter?
Me and my client, sorry.
And so, if you could hand it to the clerk, does Mr. Carter have a copy of the amended?
No, but I have a copy for him right now.
Okay, if you could hand one to him, and I will take that back and consider that as well in drafting the form of my order. If you can hand the additional copy to the clerk, I believe that would be
Do you
sufficient.
want this one too?
I got it. Thank you. Thank you.
Thank you. And I believe that concludes this matter this morning.
Thank you.
you as always, counsel. Next on the calendar